ನಿನ್ನೆ ಬಂದ ಸರ್ ಅದು
ಬಂತು ಸರ್.
ನೆಟ್ ಪ್ರಾಬ್ಲಮ್
ನೆಟ್ ಇಲ್ಲ, ಸಿಸ್ಟಮ್ ಪ್ರಾಬ್ಲಮ್ಸ್. ಸಿಸ್ಟಮ್ ಪ್ರಾಬ್ಲಮ್ ನೋಡ್ರಿ ಸರ್, ಸರಿ ಒಳಗೆ ಹೋಗಿ
ಸರ್. ಇದೇನೋ ಆದಂಗಿದೆ
ಆಗಿದೆ ಸರ್.
ಏನ್ ಬರ ಕಾಲ್ ಮಾಡ್ತೀನಿ ಅದಕ್ಕೇನು ಜಾಸ್ತಿ ಅಂತ ಹೇಳಿ ಹೋದ ಸರ್.
SVIT
ನೋಡಿ
ಇಲ್ಲ ಸರ್, ಸ್ವಲ್ಪ
ಬೇಕಾ? ಇದನ್ನ ಇದೆ ಸರ್.
ಎಷ್ಟಿದೆ ಕ್ಯಾಮ್ರಾ ಅಷ್ಟೇ ಮಾಡ್ಬೋದು ಸರ್.
ಹೌದಾ? ಈ ಸೈಟ್ ಅದೇ ಸರ್. ಸೆಟ್ಟಿಂಗ್ಸ್ ಸೆಟ್ಟಿಂಗ್ಸ್ ಎಡಿಟ್ ಮಾಡೋದಾ? ಡೀಟೇಲ್ಸ್ ಸರ್ ಅದು ಹಂಗಿದೆಯಾ ಅಂತ ಸರ್ ಒಂದ್ಸಲಿ ಚೆಕ್ ಮಾಡಿ. ಅದೇ ಕ್ಲಿಕ್ ಮಾಡಕ್ಕೆ ಹೌದಾ? ಅಂದ್ರೆ ವ್ಯೂವರ್ಸ್ ನೋಡೋದಷ್ಟೇ.
ಯಾವಾಗ ನೀವು ಲಿಂಕ್ ಓಪನ್ ಮಾಡ್ತೀರಲ್ಲ, ಸರಿ ಪಾಠನೂ ಹಂಗೆ ಬರ್ತಿರಲಿಲ್ಲ ಸರ್. ನಮಗೆ ಊಟ ಬರುತ್ತೆ ಅದು ಹುಡುಗರಿಗೆ ಸಿಗಕ್ಕೆ ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕಾಣ್ತಾರೆ ಅಲ್ಲಿ. ನಾವು ಸ್ಟಾರ್ಟಿಂಗ್ ಸಹ ನೀವು ಎಷ್ಟೊಂದು ನಾವು ತಿಳ್ಕೊಂಡು ಆಮೇಲೆ ಮೋಹನ್ ಸರ್ ಹೇಳಿದ್ರು ಅದು ಸರ್ ಕರೆಕ್ಟಾಗಿ ಬರ್ತಾ ಇದ್ರು ಕರೆಕ್ಟಾಗಿ ಒಂದು ಯಾವುದೋ OBS ಅಂತ ಏನೋ ಪ್ಲಾನ್ ಮಾಡ್ಕೊಂಡು ಫ್ಲಿಪ್ಕಾರ್ಟ್ನಿಂದ ಆನಂದ್ ಗೊತ್ತಾಯ್ತು ನಮಗೆ ಮಾತ್ರ ಈ ಥರ ಮ್ಯೂಟ್ ಮಾಡಿ.
BCA department take this opportunity to welcome you all to the awareness program on NIPAM, intellectual properties and protection in India. In today's gathering, I would like to address our speaker, Mr. Abhishek Singh, Examiner of Patents and Designs, NIPAM Officer, Chennai. Now, I request Shantakumar Sir, HOD of CSC Department, to welcome our speaker by presenting memo cake. We welcome you, sir. I would also like to welcome our Vice Principal, Dr. Lakshmi Narayan Acharya, sir. Dr. Raghavendra, sir, HOD of Mechanical Department. Dr. Abhijit, sir, HOD of CSC Data Science Department. Dr. Venkatesh, sir, HOD of Electronics and Communications. I would also like to welcome all of the professors and my dear students. I request now Dr. Lakshmi Narayan, sir, to address the time.
Good morning, everyone. Today's chief guest, respected Abhishek sir, dear HODs, convener of this program, Dr. Venkatesh, faculty members, and my dear students. It is my great pleasure to welcome you to today's event organized under the National Intellectual Property Awareness Mission, also known as NIPAM, NIPAM. NIPAM is an ambitious initiative launched by the Government of India with the aim of raising awareness about intellectual property and its various aspects. The mission is designed to educate the participants about the technologies, filing procedures, strength of IP rights, and the working of Indian intellectual property offices. The goal of this program is to create a nationwide understanding of IP rights and to encourage innovation and creativity among the citizens. By promoting awareness about intellectual property, NIPAM hopes to provide a supportive environment that encourages and nurtures the innovative minds of the country. Today's event is an opportunity for all of us to learn about the benefits of intellectual property and to gain a deeper understanding of the importance of protecting IP rights. Our speaker is well versed in the field of IP and has a wealth of knowledge and experience to share with us. So let us sit back, relax, and enjoy the enlightening discussion that lies ahead. Thank you for joining us today, and I hope you will find this event informative and enriching. Thank you. Thank you all.
Thank you, sir. Now I call Dr. Asha ma'am to introduce our speaker to the gathering.
Good morning to one and all. I, Dr. Asha K, Associate Professor, Department of Electronics and Communication Engineering, would like to introduce our esteemed speaker for today's session, Mr. Abhishek Singh. Mr. Singh is highly educated and accomplished individual with a diverse background in both academia and industry. Sir holds a Bachelor of Science degree from the University of Allahabad and Master of Technology degree in the Applied Geophysics from the prestigious Indian Institute of Technology, Roorkee. His MTech project entitled integrated geo-exploration of Sonali River knee bends, Northwest Himalayas, showcases Sir's experience and expertise in the field and dedication towards the work. In addition to his MTech degree, Sir has also holds a Master of Science degree in the physics from Jawaharlal Nehru University in New Delhi. Sir's MSc project, rigorous derivation of Born-Oppenheimer approximation, highlights the skill and creativity in the field of physics. At present, Sir is currently serving as an examiner of patent and designs at the Patent Office, Chennai, under the Ministry of Industry and Commerce, Government of India. With over 6 years of experience in his role, Sir has established himself as a knowledgeable and respected authority in the field of patent and designs. In conclusion, I am confident that Sir's wealth of knowledge, expertise, and will greatly benefit all of us today by attending this session. On behalf of management, Sai Vidya Technology, Principal Sir, and all the stakeholders of SVIT, I welcome you, Sir, for the August gathering. Thank you, sir.
Thank you, ma'am. Now I request Mr. Abhishek sir to take over the session.
Thank you so much to everyone for gathering the session and to show your interest in intellectual properties. And I would like to convey my special thanks to Dr. Venkatesh sir, who was in continuous touch with us to make it possible to conduct the session in your institute. It's been a long conversation that was going on with sir. And I convey my sincere thanks to Vice Principal sir, all the HODs who are present over here, all the faculty members, and special thanks to all the students to show your interest in intellectual properties. Before I start the session, there are many of you who are from first year and fourth year also, right? And how many of you are from computer science background? Or what is the main background that you have? Like engineering background, it is right. But civil, electrical, what it is? Electronics, mainly electronics. Okay. So you have already heard this term, this intellectual properties, right? Raise your hand if you have already heard this term, intellectual properties. I will not ask question. I will not just pinpoint that. I will not tell you to speak the meaning of it or anything like that. Have you heard this term, intellectual properties? No? Okay. Patent you have heard? Patent? Trademark? Okay, so these are the kinds of intellectual properties. I would try to not to make the session very technical or something like that. I would like to keep it a bit, easy for you. Now, before I start the session, I would like you all to please note down this website that is written over there, ipindia.gov.in. Maybe today you don't need this website. Maybe it is possible that you don't need it today, but maybe in the near future, when you are writing a book, you are writing a poem, you are making some invention, you are doing a project work, and you think that okay, I have invented something, be it very basic or something like that. Maybe in those cases, maybe in the future you want to go for a startup. In all those cases, you need the understanding of intellectual properties, and you can have all the meaning over there, IP India website. And the name of the website is ipindia.gov.in, which is a government website. All the information, all the acts, rules, manuals, everything is available there. And very authentic information is there because it is from the government itself. I am coming from Chennai Patent Office. There are actually 4 offices which are working on intellectual properties, and I am speaking here on the behalf of the government of India to spread the awareness on intellectual properties. And right now I am coming from Chennai Patent Office. There are 4 offices: Delhi, Mumbai, Kolkata, and Chennai. And if your background is, engineering background is there or science background is there, then you can also go for the same. Like, name of my post is examiner of patents and design. So as a career opportunity also you can see that in the future. And I am telling you that we are expecting some good number of vacancies very soon, where we will be hiring this engineering graduate students for the post of examiner of patents and designs. So for now, I'm going ahead, and also if you have any question, you can ask us the question on NIPAM this dash Chennai @gov.in. So these 2 at least you should note down. And now, just a disclaimer that in the due course of presentation, I might take the names of some companies, but we want to clarify that we are not here to advertise any company in any form. We are taking the names of those companies just to make presentation more interacting or to make it easier for you. Okay? And now I will start from the very basics, and then I will go to a little bit advanced slides. So the very basics is the presentation is about intellectual properties awareness. So basic question is, what is intellectual property? Now you see there is a person who is having some bulb in his bag and is running away. So what is the meaning of this bulb? Idea, right? Something that is intellectual. And the basic thing about intellectual property is, and the difference, I will start with the difference. This is the physical property. If you have a car or building or plot in your name, no one can take it from you. That is the physical property, that is the tangible asset. But and the presentation today, it is not about these properties, it is not about these properties, it is about the intellectual property. So if you have car, building or plot, land, no one can take it from you because you have the registration in your name for this particular land. You have registration in your name for this tangible asset, physical property. No one can take it from you. Why? Because you have the registration in your name. So, but there are some things which are yours, which are your intellectual properties, not the physical properties, and there is a whole legal framework in the country which is making you capable of protecting your intellectual property, which is like, you can see, this is a kind of a sketch or something, this is a poem, this photograph, I took this photograph 6-7 months back in my office only. This boy, he is making some kind of device, maybe out of his project work or something. So these things are intellectual properties. Any property that you create using your intellect is your intellectual property. Last property, this land plot, this is the physical property. Okay? But these things are intellectual property, and the session is about intellectual property protection itself. So if you are interested in fashion design, if you are interested in textile design, if you are interested in writing a poem, if you are doing some project work and you think that, okay, out of that project work you are doing some kind of basic invention, if you are doing any kind of these things, these are your intellectual properties, and you can protect them in your name. Okay? Even if you are making a sound recording, you are making a movie, that is your intellectual property. I will give you some good examples in the future. Now, this is one basic example of one of the intellectual properties. Like whenever we speak the name like intellectual property, many of the students first thing they will say like, okay, patent. So patent is very famous intellectual property, but patent is not the only intellectual property. Okay, that thing should be very clear. Now, this example is about what it is written, patent. Suppose you are the one who is making some device, you are then commercially exploiting it. You are having money out of this device that you have made. Another person comes, he copies your device as it is, and now he has also started making money. You go and stop that person, he will say, have you taken the patent in your name for this device? And if you don't have, he will say no patent, then you cannot stop me. So, if you are making some kind of device, some kind of invention, and if you want other to stop it without your permission, you stop it from using without your permission, then you should take the patent right in your name. And that patent is just one of the examples. There are other kinds of intellectual properties as well. But you might ask, okay, you are taking the session on intellectual properties. If I take the registration in my name for some intellectual properties, what is the benefit? Why should I take the registration in my name for the poem or the book I have written? What is the benefit of having the intellectual property right? Now, see, this thing what I am going to explain is what are the benefits of intellectual property right. This thing about all the intellectual properties, patent, design, trademark, copyright, all kind of intellectual properties. And there is a whole legal framework in the country. I want to repeat it, please listen to it carefully. There is a whole legal framework in the country which is going to support you if you have taken the rights for the intellectual property that you have created. Any intellectual property that you have created, you can take the registration in your name and no one can exploit it commercially without your permission if the registration is given to you for that intellectual property. So that is the first benefit, commercial exploitation. Since it is your property, you have taken the registration in your name for that particular intellectual property, no one can exploit it commercially without your permission. Second benefit is recognition. That means suppose you are given the patent right, then and you are the owner of the patent right, then on the patent your name will be there. So that recognition on paper is also there, and also commercial exploitation rights are completely yours. So for some people, pride matters more, recognition matters more, but for some people, commercialization of the product matters more, and the beauty of intellectual property rights that is given to you by the government of India is that it gives you both of the things, the pride and recognition and the commercial rights as well. That is why we keep on repeating that if you have created any intellectual property, take the registration in your name for that intellectual property. That will be completely yours. Now, there is, as I told in the beginning also, that patent is not the only intellectual property, but there are many kinds of intellectual property. If you are interested in fashion designing, as I said, or any kind of designing, this bottle is here. You can make any particular shape of some other bottle, any particular different shape which is more beautiful, having more appeal to the eye. Then what you will do? You will go for the design registration of that particular bottle. And suppose you have done some kind of textile designing or ornament designing, you are interested in that, you will go to that particular design, you will file design registration for that particular design. And but suppose you have invented something, some device you have created, then the intellectual property right associated with that is patent right. Suppose you have written a book, you are good in painting, you are good in sketching, you are writing poem. So intellectual property right that is associated with that, those things is copyright. Okay. So depending upon the work you are doing, depending upon the intellectual property that you are creating, you apply for the separate kind of intellectual property right that is associated with that work. This classification should be very clear in your mind. Okay, so intellectual property right is just not about the device and patent, it is having a very broad span of area which is covering. Okay, not only okay. Now, what it is written, all I asked was, can I patent my copyrighted trademark? So we keep on hearing from students this kind of a statement. All I asked was, can I patent my copyrighted trademark? This statement is completely wrong. Because, as I said, patent is given to some other area, copyright is given in some other area, trademark is given to some identity of the brand. So, students make this kind of wrong statement when they are not very clear about the classification of the intellectual property. But yes, when they say, they know, okay, he knows a bit about intellectual property and he knows that he has rights over the intellectual property that is created. He knows there is something that is called trademark, there is something that is called patent, there is something that is called design. Okay, so this classification should be clear and we will start our discussion from the first intellectual properties, that is patent. You are from engineering background, so mostly we will cover this patent section elaborately and copyright we will cover elaborately and the other four we will just touch them. But the basic information I will give. Now I will start from the first intellectual property, that is patent right. Okay. And patent is given, I will start from the very basic definition. Patent is given only and only to invention. This is important because sometimes we receive the application in which computer programs are there, or some application in patent section where there is just design, just the appeal to the, like the bottle design has been changed or something like that. So we want to tell you, please do not file those things in patent section. The very basic thing in which the patent right is given is, patent is given only and only to an invention. Like a book cannot be given the patent right. Sketching, drawing, painting cannot be given the patent right. Even computer programs are not patentable subject matter. Computer programs are given a different kind of intellectual property, that is copyright. Okay, so it should be very clear that patent is given only and only to invention. So intellectual property right that is associated with the invention is patent right. Now all of you know him, right? Michael Jackson. And in this example, he is actually making his famous dance move, and it is looking like he is defying the gravity. A normal person can tilt around 15 degree or 20 degree from perpendicular, but he is able to tilt around up to 45 degree. Now the basic question is, how was he able to do it? So the secret was hidden in his shoe. And even the patent application was filed for this particular shoe. Some kind of invention it is. So some kind of nail is coming out of the shoe when he is making his dance move. Some kind of nail is coming to the shoe. It is sticking to the ground over here. He is tilting around 45 degree. He is getting back. The nail will go inside again, and then he will be able to move again. Okay, and this application was filed in United States, and in the circle the names are there as the inventor Michael J. Jackson, Michael L. Bush, Donis Tompkins. So these three names are there as alleged inventor. But the question is why I included this slide. Please listen to this carefully. If you are in your fourth year, you are doing some kind of project, and you are thinking that okay, you have done some basic invention. We are not expecting here some extraordinary or something invention. Like I want to tell one thing very clearly that when the patent term comes, many of the time applicant or I would say even students or research scholars, they have first impression sometimes that okay, patent is given to something which is extraordinary, something like a special theory of relativity, general theory of relativity, or something like that. It is not the case. If you satisfy just some basic criteria, then even the simple invention, I'll show you some very beautiful examples after a few slides, that even the simple inventions are given the patent rights. This is very important. And when you are thinking that okay, you are going to apply for patent right for your final year project, then you think okay, how do I write patent? How would I write it? How to approach office? All things will be covered over here. But this particular by this particular thing, I wanted to show you one thing, that there is one website, patents.google.com. Okay, this particular website is there. If you are in your final year and you are thinking that you have done some basic invention or anything like that, then you take the keywords of the work that you are doing and put the search box of this website, patents.google.com. Click enter. You can find thousands and thousands and even lakhs of documents which are similar to your work. So you then, and that is the first thing that clicks to the mind of any inventor. The moment I will invent something, and the moment I will think, okay, I want to file the patent file, I want to go for patent filing in Indian Patent Office. Then what is the first thing that will click to me? I will think, okay, has the same work already been done? Someone else has the patent right for that or not? So where will I check? I will go to patents.google.com. I will put the keywords associated with my work. I will click enter and I will find some patents which are similar to my work. I can refine my search by changing the keywords, and I can find closer and closer documents which are very close to my work. I can find some documents similar to that, and not only that, since I will be able to see thousands of documents, patent documents, I will be able to see that okay, how to write patent. What are the parts of patent? Abstract, description, drawing, claim. These things are the parts of patent document. And this is not very tedious. Writing a patent application is not very tedious. If you are writing your final year project thesis, or you are writing your PhD thesis, you are writing research papers. If you are qualified to write those, then you are qualified enough to write a patent application. I am telling you repeatedly. I am telling you that writing a patent application is not a very tedious task. I would rather take risk of saying that it is easier than writing a PhD thesis or writing a good research paper. It is very easy. It is not hard. So if you are in your BTech final year, you just go through the patent documents which are freely available on this website, and not only this website, IP India website is also there. There is a public search. You click the public search, you put the keywords, you can find a lot of documents. So lakhs and lakhs of patent documents are freely available on these websites. You go through them, that how to write, and also find the documents which are closer to your work, and you can write the patent application. And if you have made some mistake, we are always there to help you. It is not that you will write something, it will come to us and we'll just keep it aside if it is not written properly. It is not like that. We are always there to help you. Okay? Now I'm going to give you some examples from which you could get to know that okay, what kind of things can get the patent rights. This child, she got the patent. For what? Like in some areas, flood prone areas are there. What happens when the flood comes? A large amount of water in the night, it might rush into the houses. Then the people who are not very quick in moving, for example, old citizens and children, pregnant ladies, those who are not able to move very quickly, there is a high chance of them getting drowned into the water. So those things are there. So a lot of loss of life happens in the flood prone areas. What did she do? She made a kind of house having a zip from the top to bottom. When the water will rush into the house, what will happen? That zip will open, and this will be a kind of floating boat on the water. The whole home, the whole house will become a kind of floating boat on the water. So that thing that is very beautiful. It is not very complicated invention. It is a simple yet very useful, very beautiful, life-saving example. And she was given the patent right. Another example, it was about one example I just included to show you that how a simple applying your brain beautifully you can. She made a kind of a washing machine which can be run by just paddling it. Another example, a lot of you might be playing cricket, and generally you will see like when we were a child, we used to see this stump, right, wooden stump, and in the cricket the rule is what? When the ball is hitting to the stump, the player is not out if one of the ends is touching to one of the stump. Both ends should be in the air. Both ends of the bell should be in the air. Then the player will be out if the ball is hitting to the stump and he is not inside the pitch or things like that. So both ends should be in the air, then he will be out. And this is not a very easy task to be judged by the umpire. They take chances, there is a chance of error is also there. And for decades, things were going on and on and on, and there were right and wrong decisions were also there. But very recently, this invention came not too many brains did this came. So what will happen? The moment this bell will be in the air, it will there is microprocessor, sensors are there. Then only it will blow. These both things, this thing and this stump, they will blow only the moment this end also leaves the stump, this end of the bell. So that then the decision is going to be very fine. So beautiful thing about the ideas and invention is that we all have been watching the cricket for decades. But the one who applied a simple brain for a simple invention is now making millions of dollars. Because no one can make this without the permission of the owner of the patent right of this stump. So this is also given the patent right, and definitely is making millions of dollars. So it is how a simple invention can be given the patent right. Final example of the same. When you are driving a car, you have indicators. You give it and you are safe that okay, you are taking right or left. When you are riding a bicycle, then suppose you are riding a bicycle in the night, you are taking a right turn, you are giving your hand like this, and the car from the back, they cannot see it, and you are struck down. Some accident happened. So what did this person did? He invented this helmet. Right side and left side, he can, just by putting the button, he can blow these right or left indicators so that the car coming from behind or any vehicle coming from the behind, they could guess, okay, he's taking right or left. Then when he is putting brake, accelerometer is there. This back side will blow. Then something coming from back, okay, they have to know it is stopping. And not only that, it is like suppose he is he has fallen in some remote location, some accident happens, then there is emergency call window is also there. In already fed number, emergency number, the call goes. So it is also saving lives, and the invention is not very complicated. Just apply simple brains, and if it is satisfying some basic criteria that okay, this work is new, this is the inventing, it is given the patent rights. Okay, so please take fear out of your brain that okay, patent is given to something far-fetched thing or something like that. It is not the case. Okay, so this is one of the example where I showed you that even the simple invention are given the patent right, and monetarily speaking, definitely money is heavily involved in this. They are having the benefit out of their patents. Now another thing is patent is an first definition I gave, patent is given only to an invention. Second is patent is an exclusive right. If you have taken the patent rights for the invention that you have created in your name, then you can exclude others from using it commercially if you don't want them to use it. You can push that person away. No, I want to use it myself, or maybe I want to exploit it commercially myself, or I will allow someone else. I don't want you to use it. So that is why also patent is called a kind of negative right. It is a kind of any intellectual property is for that matter is a negative right. Okay. Now patent is given by sovereign or state. Who is giving you the patent right? Is it government of India? Is it state government? Is it Karnataka government, Tamil Nadu government, or is it a government of India, or what it is? So patent is given by sovereign or state, which in our case is the government of India. I am doing job under government of India. The name of my post is Examiner of Patents and Designs. What do I do? When your invention, you are writing an application, your invention you are writing in detail, what will happen? It will come to Chennai Patent Office. What I will do? I will go through your invention, I will read it in detail, I will try to find some documents which are similar to your work, and I will try to find whether it is inspired from somewhere or some work has already been done or something like that. So who is doing that work? Government of, or I am doing the work assigned by the government of India only, not state government, no private agency, no other person is allowed. No one is involved other than the government of India. So patent is given to you by sovereign or state, which in our case is only government of India, and the rights are territorial. This is very important, very interesting. Rights are territorial and search is global. These two lines, rights are territorial, search is global. Right that I give to you, that the government of India is giving to you, is territorial. It is valid only inside the boundary of government of India. But if you want to have the patent right in United States, then you have to apply separately in United States. If you want to apply have the patent right in Britain, then you have to apply separately in Britain. Okay, depending upon the country in which you want the patent rights, you have to apply separately. Why? Because the patent rights are territorial rights. So the right given by the government of India is valid only under the political boundary of India. And the search is global. Search is global means when I am searching for the documents to judge your invention, when I am searching for the documents which are similar to your one, that search will be global. Okay, so I am searching for, I can even cite some work from YouTube. So any work that I am looking for in order to compare your work, that search is global. But the right that we will assign to you is territorial, and that is why there is nothing that is called international patent. Even some faculties, sometimes research scholars, they use this term international patent. There is nothing that is called international patent. Why? Because the patent rights are not international, these are territorial. Okay? But up to how many years? If you are given the patent right, you are going to exploit your work commercially up to not eternity, up to 20 years only. So you are given the patent right up to 20 years, you can exploit it commercially. After that, it becomes public property. After 20 years, anyone can make product and they can exploit it commercially without your permission. So up to 20 years, right is yours. Now, from this slide, I will show you the power of the patent that you take for your even for simple invention. That invention that you are making in home or anywhere. Because when this person, Mr. Osher, he invented this spin brush. This spin brush it does not require some high-tech research laboratory in NASA or something like that. Even sitting at home, you can find some idea. Okay, I can make something like that. So this is the same kind of invention, spin brush. He was given the patent right in United States, and then there is company Procter and Gamble company. They got interested in this spin brush. They thought that they could, of course, make a good amount of money. So they approached the holder of the patent, Mr. Osher. And Mr. Osher sold the patent right in how much money? 475 million US dollars. 475 million US dollars just for this simple invention. How could he have it? Because he had the patent right. Without his permission, no company could make it. So he could do it, he could charge this much only because he had taken the patent right from his country. If he would not have taken it and he would have published it somewhere, then anyone could make it, exploit it commercially. But he had taken the patent right even for this simple invention. So he was given the 475 million US dollars just to buy this particular patent. So this example shows the power of patent and also the level of monetary benefit you can have. 475 million US, if I roughly convert it in Indian rupees, suppose you would have done it, then how much money you would have? 3524 crore Indian rupees. Another simple invention which you can have, for which the patent right was given, was this ring pull can. The inventor invented it to the patent right, and then Coca-Cola company got interested, and they approached this person. This time, the owner of the patent right, he did not sell the patent right, rather he gave a license. He charged the license fees as the 1/10 of a penny per can of Coca-Cola. And for this, how much he was making? 1.48 crore rupees per day he was earning by charging it to Coca-Cola. So this is the example where you see that not only the simple inventions are given the patent right, but also the power of patent right. You can see that no one could copy it. The company as big as Coca-Cola and the company as big as Procter and Gamble, they could not even snatch it, copy it, steal it. They had to approach the person. That is the power of patent right, and also you see the monetary benefits involved in it. So now, this thing is very important. If you are, you have to be very careful about this particular thing. That if you have invented something, do not just rush and publish it anywhere. No. This is very important. Be careful about publishing your work before filing the patent application. All these three are saying, I should not have published before filing. Suppose you are inventing something, your father is very happy, he got excited that okay, my son or daughter has invented this kind of thing and he got it published in the newspaper. He gave the information on some website about the detail of your invention or something like that. Then what is the risk involved in that? Suppose your father has given the invention detail in some website or in some newspaper. Then you think, okay, I want to go for patent filing. What you will do? You will apply for the patents. You will find the application. It will reach to Chennai office. In Chennai, it will come to me. What I will do? I will read your application in detail. First thing, what I will do? I will start looking for the documents which are similar to the work that you have already done. And then I come across your work which is published on the website. Before filing the patent application, your work is already published somewhere. And I come across it. What I will do, I will cite that work that okay, it has already been published. And then I will give you getting the chances of having the patent right for that work. So your work itself is killing you getting the chances of the patent right because you have already published it. You don't have to do it. You do not publish your work before filing the patent application. You publish your work even after 1 day of filing the patent application, that is fine. You are filing it in Chennai office today and tomorrow you publish it in any newspaper, not a problem. But not before the patent application file. Do not publish your work. So this thing is very important. And the heartbreaking story about that kind of particular incident happened in 1975. This is a very famous Milstein story. Mr. Milstein, he gave a very good presentation in 1975 somewhere about monoclonal antibodies. He had invented something and then he got his work published in the eminent journal Nature. He got his work published before filing the patent application. And here he made the blunder. He did the blunder. He missed the patent application just based on this fact that his work was already published. Be it in Nature, be it PRL, be it any eminent journal, it was published. Since it was published before filing the patent application, his work was rejected. And his work was so genuine that along with Mr. Kohler, he was awarded Nobel Prize. He was awarded Nobel Prize for his works. He was such a genuine scientist. He was awarded Nobel Prize, but law is law. He was declined the patent right. And it is not just a very one single story of a one single scientist. The point is, there was a huge political uproar in Britain. Whole politics of Britain was shook because they did not want. I mean, that was such a great invention that Britain wanted the patent for that. But he had made a mistake and it was all gone. So that blunder you don't have to make. In the future, when he was asked that whether he is sad that he missed the patent rights for this particular great invention, he said, I was not sad, Miss Thatcher, Miss Margaret Thatcher. Miss Thatcher was sad. So it was his generosity, it was his simplicity and greatness that he was not sad that he missed the patent right, but technically he missed the patent right. Technically speaking, he missed the billions of dollars maybe. Okay? So this example you should keep in your mind. Don't publish your work before filing the patent application. Now, I repeatedly said that patent applications are not given to something far-fetched, something extraordinary invention. No, it is given even to simple inventions if they satisfy some basic criteria, the criteria that we look into in our offices or in general in other patent offices abroad also. These are basically like this only. Your work should be new, your work should be novel. That means it should not have been published anywhere else as it is. Your work should have some inventive step. And that inventive step means some technical advancement over already existing technical knowledge. That inventive step should be there, some technical advancement should be there. And if there is no technical advancement, even if there is no technical advancement, but economic significance is there, huge economic significance is there, even then it can be considered inventive. So your work should be new, your work should be inventive, and it should be able to be produced in industrial application. So if your project work of your 4th year, your final year, is something new, it is not just the copy paste, it is not just the downloaded material from some internet or something. If it is new and it is satisfying these 3 criteria, I would request you all to please consider for the patent filing for your work. And this particular thing is there, your work should satisfy these three things, and it should not fall under section 3. I will not make this slide technical, but at least you should know one section, that is section 3 in Patents Act, and that tells what things are not considered invention. Like your work should not be frivolous, your work should not be against morality. For example, you have invented a car, and that car is very good in kidnapping people. Okay, so you cannot claim that okay, my car is novel, my car is inventive because no one ever thought of kidnapping people in this way. So it is inventive and it is capable of industrial application. So it should be given the patent right. No, no matter how much novel it is, how much inventive it is, how much capable of industrial application it is, if it falls against the morality, section 3B, it will not be given the patent right. So section 3 in general, it is available on the website. It tells what are the things which are not given the patent rights, even if they are novel, inventive, or capable of industrial application, they will not be given the patent right. And for example, method of agriculture or horticulture in India, these are not given the patent rights. Okay, so this section you can download and you can check on the website. It is available. Acts and rules and manuals are available on IP India website. You can find it there. Now you will think, okay, I have done my project work. It is new. It is having some technical advancement. I want to go for patent filing. What you have to do? This is two ways. Like if you want to submit the hard copy, you are most welcome. Visit our office in Chennai, Delhi, Mumbai, Kolkata, wherever you want to. So you can visit our office. You don't want to come to Chennai, it is very far. Then you can send it to us by post. You don't want to send your work by post or you don't want to visit to our office, then there is website, e-filing is there. Just visit IP India website. There is comprehensive e-filing is there. Click it, download all your documents. Sorry, upload all your documents. Okay, and it will reach to us. So it is as simple as that. It is just that you are not aware that things are very simple. You can just visit the website, upload your documents. And what you have to upload? These 5 forms available on the website. 5 form 1, it is about simple. What is your name, like the way you fill some school application or something like that, formal information. What is your name, nationality, these things. Form 2, detail of invention, your whole work. Form 3, you will mention whether you have filed in some other countries or not. Form 5, you will say, I am the applicant, who is inventor. Name of the inventor should be there. So, and Form 18, which is request for examination. Recently, I came across a case, and it was really sad. I came across a case. The professor, he had submitted Form 1 along with fees and Form 2. Then he thought, I have submitted the fees, I have submitted my formal information, and I have submitted the invention. So, I am all done. It will be examined automatically. He made the mistake of not submitting this Form 18. Examination in patent office is not automatic. You have to submit this Form 18 also along with this piece, which is for the request of examination, and you have to submit it within 4 years, 48 months of filing your application. So you have to be very careful about Form 18 also. So he did not submit Form 18 and he was sitting and waiting why the reports are not coming, whether I got the patent or not is not coming, the result is not coming. But he had already crossed these 4 years, so we could not also do anything. So within 4 years, you have to submit Form 18. Okay, so these are the 5 forms which are very simple to be filled. These are the 5 forms. You have to submit these 5 forms along with this fees structure. All will go to the Government of India. This fees structure, since you are natural person or educational institute, This will be the fee structure for you. This is for the other than natural, which is at the higher end. This is for the kind of company thing. But for you, it is just natural person and educational institute. So with Form 1, it will be 1600 only. Form 2, no fees. Form 18, the final submission for examination, you have to submit 4000. In total, it will be 5600. So in this, with this fee structure, and also it is written with Form 2, no more like up to 30 pages and up to 10 claims there are no fees, but it does not mean that you cannot go beyond 30 pages or beyond the claims. It is just that per extra page and per extra claim you have to submit some fees, and there is no upper limit to pages and claims. But this much of fees, up to 30 pages and 10 claims, this much of fees, these forms, this mode, and it will reach to us, we will examine it. Okay? Now, I think I have covered the most elaborated section, and that was about patent. If you have any doubt about patents, I will take the question at the end, not a problem. Now I am going to give you information a little bit about other kinds of intellectual properties. First intellectual property was patent, we have covered it. Then we are coming to design, and then I think you will really like the copyright section, and then two more, but those will be just one slide each. For now, we are going to getting into next intellectual property, that is design registration. So, as I said in the beginning, that you might be interested in some kind of fashion designing, textile designing, utensil designing, furniture designing, bottle designing, anything. If you are interested in any kind of design which is going to add some aesthetics value to the product, you can go for design registration in your name. Okay, you can see there are many bottles over here, and companies are very much particular about the shape and size of this bottle. Why? Because the designs are going to add some aesthetics value to the product. And don't underestimate design registration. Many of the times people underestimate the intellectual property. But it is having a great commercial value. Many of the times you would have heard in advertisements, नए पैक में, same सर्फ और साबुन नए पैक में. Why? Just to attract people for the new design, and those designs are always also registered. What happens many of the time, customer is going to choose one product over other just on the basis of design, and by that designs are going to add commercial value to the product by adding the appeal to the product, aesthetics value to the product. Okay, bicycle. All bicycles have almost same functional features. All wristwatches have almost same functional features. But when children go to take this bicycle or you go to take this wristwatch, what is the first thing that you notice? The design. So design registrations are also given by our office. And when I bought this pen 6-7 months back, why did I buy this? Honestly speaking, I think I have that pen still. This is the pen. Why did I buy this? Not because it was writing very good. It was just on the wall. I saw that pen. I thought, okay, it is looking nice, and I just bought it. So you see the whole procedure. Why did I buy this? Because it caused an appeal to my eyes. Okay, since it caused some appeal to my eye, I bought this. Now, when we in our office, when we make judgment on your application for the design registration, what we look into? For patent, I told you, we look for novelty, inventive step, and capable of industrial application. For patent, those are the criteria. For design, what is the criteria? The same thing is the criteria, judging by eye. We don't look into the functional aspect of the design. This is very important. If you are designing something, recently I went to one medical institute. What happened? They were saying that they had designed something and that thing was mixing gases in a very nice way. So they had designed the whole, some kind of invention was there. So what happened? They applied for the design registration because they thought, okay, it's a new kind of design, but it had some technical feature also. They should have gone for the registration for patent also, design also. But the mistake they committed, they went only for the design registration, they did not go for the patent registration. Why I am saying this example, the reason is this: when you have made some design which is having only appeal to the eye value, aesthetic value is there, then you go for design registration, because in judging the design, we just look into the appeal for the eye it is causing. But if the design has some technical feature, then you go for the patent filing also. This point is very important. So, but you have to do it within limited time frame. If you want to file both of them, then you have to do it in a limited time frame. So, what I have written, that design must be an appeal to the eye. If it is having some functional features, that will not be taken into consideration. Functional feature will be taken consideration into patent. So you should go for patent filing also. If it is partially functional and partially appeal, then in judgment only the appeal to the eye is taken into consideration. Now these are the examples. There are many such examples in which you can apply your intellect. You can go for design of these things, and you can have the rights, design right for these things. Fashion designing, ornament designing, utensil designing, ornament designing, furniture, property. You can design anything of your choice, and you can go for the intellectual property registration for the design registration. Anyone can tell what is it? Anyone ever came across this photograph? What is this? Anyone? This thing was given the design registration for this particular chessboard. This is a chessboard. A chess can be played by two people, but this particular chessboard can be played by 6 people together in a pair of 2 or in a pair of 3. This boy, Hridayeshwar Singh Bharti, he designed this. Depending, as I said, based on your choice of the article on which you want to apply design, you can choose if you can design it, you can go for the design registration application. He chose chessboard and he modified the chessboard in this particular design, and he was given the design registration, I think, in 2012, 10-11 years back, and at that time he was the youngest till date to have the design registration from our office. And despite that, he was suffering from Duchenne muscular dystrophy, which is a rare disease and which happens, like, it is very fatal. So at the age of 19 only he passed away. 2 years back in June we lost him. But he kept on modifying this particular design. In many years he kept on modifying and changing and adding new features. So he is the source of inspiration not to masses in general, or you, or even he is source of inspiration to our office, which is actually respecting the intellectual property. He was able to use his intellect in such a fascinating way. So you can choose the article of your choice, you can apply design, you can go for design registration, you can apply that application in our office. The process, you will just take some photograph, 2 set of representation sheet I have written. You will take photographs with form 1, everything is available on website. All forms are available on website, everything. And some fees to apply. And the photograph you have to take, for example, here some teapot is here. You can design teapot. So that number of photographs you can send to our office along with the form 1 and fees. So that is all required for design. And for the life of patent was, anyone? How much was the life of patent? And life of design is 10 years. Subject to the extension, some extension can be given for 5 years. in patent there is no extension given. So maximum life of patent can be 20 years. After 20 years, it will become a public property. Anyone can use it. Design, it is maximum is 15 years. 10 years plus 5 years subject to extension. After 15 years, it will become a public property. Okay? I hope this section you would like. I'm not sure how many of you are interested in writing a book in future, but if you are planning or if you have any interest in writing a book, I will greatly encourage you to go ahead and complete the book. Maybe you are in your BTech 4th year, right now you are not writing, but in future if you want to write, please do write the book. I will tell you the benefits. What are the benefits of having the copyright? As I told you, patent is given only to invention. Design is given to some aesthetics value added to the product. Copyright is given to 6 sections, not 1 or 2. Literary work, you are writing a poem, you are writing a novel, you are writing a book, that is given the copyright protection under literary work section. You are painting something, you will be given the copyright protection under artistic work section. You are composing music, you will be given the copyright protection under musical work section. So depending upon the work you are doing, you can be given the copyright protection in 6 sections. And I told you that computer programs are not given the patent right. Okay? But it does not mean the computer program is not at all intellectual property. No. In today's world, computer programs are one of the smartest intellectual property you can say. It is just that computer programs are not given the patent right, but the intellectual property right that is associated with the computer program is not patent but copyright. So if you are writing a computer program, your friends are writing some computer program for some software, some web designing or whatever, do not file the patent application, file for the copyright, and they will be given the copyright protection for that particular computer algorithm or program under literary work section. This is very important because sometimes we keep on receiving the patent application for computer program. No, computer program will be given the copyright protection. Now this photograph, when I took this photograph 7-8 months back, this photograph in the background it was taken by me in the office. Through the example of this photograph, I will tell you the difference between the author and owner, authorship and ownership of copyright. I told you that copyright protection is given in 6 sections: literature, drama, art, music, movies, cinematographic film, that is movie, and sound recording. So these are the 6 sections in which copyright protection is given: literature, drama, art, music, movies, and sound recording. Now, when I took this photograph, I have the copyright protection for this particular photograph under artistic work section. Fine. So this particular, the question is, who is the author of this photograph? Answer is, I am the author of this photograph. Another question is, who is the owner of the copyright associated with this photograph? The answer in my case is, I am also the owner of the copyright associated with this photograph. But if I would have taken this photograph under some job obligation from Discovery Channel or from National Geographic Channel, or someone would have paid me to take this photograph, then I would still be the author of this photograph, but I would not be the owner of the copyright associated with this photograph. The owner of the copyright associated with this photograph will be my employer. So if you are writing a book under some job obligation, some institute have paid you to write that book, not teaching. They have paid you not for teaching, I am repeating, they have paid you to write that book, and then you are taking the copyright protection for that particular book, then the copyright owner will be the institute, and the author will be you. That is fine, no one can take that right from you, you will still be the author, But since you have done the job of copyright work under some job obligation, then the owner will be your employer. But if you have not done the job under some job obligation, you have done it on your own, by your own choice, you have not paid for it, then you are the owner, you are the author. For example, when Krishna is here, I was writing emails to him, and he was writing emails to me for the conduction of this program. So I was writing those emails. Who is the author of those emails? I am the author of those emails. But next question is, who is the owner of the copyright associated with that email? The answer is the government of India is the owner. Because government of India, I am government servant. Government of India is paying me to this particular job. So the owner of the emails, copyright associated with that email was government of India. Okay, so I hope this concept is clear for you. Ownership and authorship of copyrighted work that you have created. Okay. Now this is very famous idea expression dichotomy. Based on this dichotomy, a lot of court cases are there pending and fighting. This is very not only very, but it's the most important, is the backbone of the copyright protection, I would say. Idea expression dichotomy. One example I would give, suppose you are sitting on a tea with your friend on Valentine's Day today, and then you are telling your heartbreak story to your friend, and you are crying a lot. Your friend is listening your sad story, and after listening your story, he writes a whole novel. You cried so much that he could write a novel. Then then copyright protection was given to that novel. Now my question is this: who is the owner of the copyright associated with that novel? Is it you who has told your sad story to your friend, or is it your friend who has given expressions to your feeling and he has written a whole novel? After this example, I think it should be clear to you. So I am going to give you an example. This famous case happened in 1978. Mr. R.G. Anand was there, who was having a play Hum Hindustani, and some people saw his play. They wrote email to Mr. Anand. They contacted him and they said that they are very much interested in making a movie based on his play. They want to discuss it. So Mr. Anand said, well, fine, I don't have any issue. I am ready to discuss. Mr. Anand talked with those people, explained his plot and everything he told. Then those people went back. And when they went back, they wrote to Mr. Anand that they are no more interested in making any movie based on his novel, based on his play Hum Hindustani. Mr. Anand said, well, fine, if you are not interested, not a problem, but you have already heard my plot, but it is okay. If you don't want to make, don't make, not a problem. It is all done. After some time, Mr. Anand came across this movie, New Delhi. And then, in his words, he was shocked. He felt that this movie is a clear copy of his play. His plot was already discussed, and it is a clear case of violation of copyright. So he went to the court. In the court, he said that, Lord, they came to me, they talked to me, they copied my plot, they have written me email, now they have went back, they told that they don't want to make movie, but eventually they came back with this movie and they have copied my whole work. Court, after a long hearing, after going through everything, long hearing, they said, Supreme Court, it is a very landmark judgment it is. They said, idea, plot, historical fact, subject matter, they can be copied. If someone is copying just your idea, it is fine. copyright protection is not given to plot or idea. Copyright protection is given to expressions. If they have copied the expression as such, then they are breaking the law. But if they have just taken the plot, it is all fine. They can do it, not a problem. And this movie was allowed because the expression was not copied. The basic plot was taken. So, there is one more point: historical fact. Supreme Court said historical fact can also be copied. For example, there was a Panipat War. You have heard Panipat War, or War of Talikota War. You have heard Talikota War in history. Okay, I think it was about the Vijayanagar Empire demolition, final demolition, 1565, I guess, 1565. So, if copyright protection is given to historical fact, Panipat War, so first person who made the movie of Panipat War of Panipat, if second person will start making it, the first person will take claim, no, I have already made a movie based on it, I have copyright protection, you cannot make a second movie based on that. But this is not allowed. That is why historical facts are not allowed, are allowed to be copied. Copyright protection is not given to historical fact. If this is allowed, if the copyright protection is given to the historical fact, then the cultural growth will altogether stop. First person who made the movie on Akbar Babar, that will be the last movie. No one can make it the next. No one can make the next movie. So that is why this historical facts are allowed to be copied. Plots are allowed to be copied. Ideas are allowed to be copied. Similar next case happened. On Sahara TV, this serial aired, Karishma, the Miracle of Destiny. Karishma, the Miracle of Destiny. So someone saw this serial, and that person had also read one famous novel, A Woman of Substance, that was published in 1979. So when he saw, that person saw this serial in 2003, it aired, Karishma, the Miracle of Destiny. That person wrote to Miss Barbara Taylor, who was the author of this novel. And that person said that it looks like the serial is a clear copy of your novel. All the way from New York, she flew to India. In India, she went to Kolkata. In Kolkata, she went to lower court, and Ms. Barbara Taylor, then she went to High Court. In the High Court, she said that it is a clear copy of my novel, it should be stopped. Court, after going through long hearing and everything, courts repeated the order of 1978. They repeated same order. They said it's fine because the expressions are new. We cannot just stop this serial. Maybe some basic plot might have been taken. Some girl is there who is struggling in the early marriage is there, probably she becomes widow also. Then in corporate world she starts making money, and then the family politics around that money. So that basic plot might have been copied. It is all fine, but the expressions are completely new. Indian and language and dialogue, everything is new. So expression is given the copyright protection, and since the expression is not copied, it is all fine, and it is allowed to go ahead. The serial was not stopped because only the basic plot was taken of the novel. So, so my question, which was there, that if your friend has written a novel based on your story, the answer is if he has just taken basic plot and he has written a whole novel with all his expressions, it is fine. It is his copyright. He is the owner of the copyright. But if it is all your expressions are there, every word you have uttered and he has just written, then it will be your copyright. Okay? So you have to just mug up this line. Copyright cannot protect an idea, and just these three things you have to mug up, and then in writing a book or anything like that. Okay? Copyright is a kind of bundles of right. I have included this slide so that I could encourage you. In the beginning also I told you if you are planning to write a book, please write. If you make one masterpiece in your life, just one masterpiece, and you can have the copyright protection for the same. For the rest of your life, even the generations will be safe, monetarily speaking, generation will be safe. I will tell you how. This slide and next slide. Copyright is a bundle of right. Suppose you have written a book and someone wants to reproduce it. They want to reproduce your book. You have already taken the copyright protection for your book. Someone wants to, some entity is there, entity one, that approaches you and that entity says that we want to reproduce your book. What you will do, you will sell your right of reproduction to that particular entity. Second entity comes, that says they want to distribute your work. You can write of distribution, you can sell to second entity. Then there is a third person who says that your book is very nice, your novel is very nice, we want to make a derivative work, we want to make a movie based on your novel, we want to make a play based on your novel. Then you will sell that right to the third entity. Then fourth entity comes, that tells that they want to communicate your work publicly. That right you send to fifth entity. Then another entity comes which says that they want to do some kind of public performance based on your book, novel, play, whatever it is. Then you sell that right to the fifth entity, sixth entity, seventh entity. All I mean to say is that there are so many of rights under copyright protection. You sell all of those copyrights to all of 5, 6, 7 entities, and you can have royalties, separate royalties from all of them. Okay, so that you can say safely that copyright is a layers of right. It is written, it's bundles of right, and all those rights can be assigned to separate 5, 6, 7 entities. So you make one masterpiece, and it is going to be taken hand to hand like anything. Another point in the continuation is that life of patent was 20 years. Life of design was 10 years plus 5 years. Life of copyright, it is fascinating. Life of copyright is, I told you in how many sections copyright is given? 6. Literature, drama, art, music, sound recording, and movies. So, out of these 6 sections, if your work fall under these 4, literature, drama, art, music, the copyright protection will be there for your life plus 60 years. You know that your generations many generations will be having the royalties that you have been receiving now up to 60 years after your life. And for the remaining 2, the movies and sound recording, it is 60 years from the date of release of the movie. So that is the life of copyright. It's very encouraging, up to 60 years, life of author plus 60 years. So you make one masterpiece, not only one but many, but at least make one masterpiece, one thing. And then these bottom 2, these are not the copyright, broadcasting right, performance right. It is copyright life rights. Okay. Now, just 3 intellectual properties we have covered: patent, design, copyright, and now only 3 are remaining. And out of these 3, last 2 are 1 slide each. And this trademark has just 3, 4 slides. So we will be winding up soon. I expect you not to worry too much now. Okay. So trademark is another kind of intellectual property. Okay. So what is wrong here? Okay. Abibas, Pespi, Puma, Bisberry, and Cool Gatte. So identity of the brand are stolen, and you all know I'm not going to tell you what is trademark and things like that. Trademark is the identity of the brand. Okay. And you all know this symbol, right? McD and Coca-Cola, Adidas. This sign is Nike. So these are the identity of the brand, which carry the goodwill of the brand. Companies are very much particular about the trademark, and One example, you know him, Elon Musk. So he is the owner of Tesla Motors. This name Tesla Motor, it was not originally with Elon Musk. He was with this name was with someone else. And Mr. Elon Musk, when he started his things, he was very particular about this particular name. So he sent one of the nicest guy, very nice guy of his office, to that person and request him to sell this Tesla motor name to him. That person said no, he was not interested. But when repeatedly requested, he sold it in 75,000 US dollar. Just the name, Tesla motor, that trademark, that was sold in 75,000 US dollar to Elon Musk. This meta, written this meta and this symbol together, it was originally not with Facebook. It was with some US regional banking company. Facebook got particularly interested in this thing and they bought it in 60 million US dollars. Just that trademark, particular trademark. So companies are very much particular about the trademark. Now, this information in the last two slides of the trademark, this is I am going to give you, and it is very important. You should listen to this very carefully. If you are planning for a startup in your future, then you should listen. Trademark registration is not mandatory in India. You can have your own trademark by the way of practice in the market. You can earn your name and have a trademark. That means registration of trademark is not mandatory. Still, standing over here on the dais, I am requesting you to take the trademark registration. The reason is, with one example, I will explain you. Suppose right now I am in Bangalore. Suppose I start making good quality t-shirt. Very good quality t-shirt. I put my name, Abhishek is there. I will write something with some design, Abhi or whatever, as a logo, and I start selling it. And I am making good market in 6 months, 12 months, or maybe 1-2 years. I have a good grasp on the market. And then I get to know that someone sitting in Rajasthan or maybe in UP, they have also started making t-shirt exactly matching with my logo. I will go to the court. To the court, I will say, my lord, you should stop that person because he is harming my market. He is using my name without my permission. And once he starts making bad quality of t-shirt, it's my name which is going to get a bad name I am going to get. Because people will not know that who is making bad quality t-shirt. Even I am producing good quality t-shirt, he is making bad quality t-shirt and my trademark is being vested, and of course he is using my trademark without my permission. So you should stop him. What court will ask? Have you registered your trademark? What I will say? I will say I have not registered my trademark, but it is not mandatory. Taking the trademark registration is not mandatory, so I have not registered it. So court will say, okay, fine, we agree, not a problem. You prove two things: similarity between your logo and his logo, which is very easy to prove. Even the judge can see, okay, similarity is there, almost same, so he can judge it. Second thing is very tedious. The court will say me to prove my presence in the geographical area associated in Rajasthan or UP. This task is very tedious. Even if you have some presence in Rajasthan or UP, maybe you will not be able to prove it. But if you have already taken the trademark registration in your name, then you don't have to prove this second part. Okay, so that here is the point where trademark registration makes play a very major role. Okay, that is why you must take the trademark registration despite the fact that trademark registration is not mandatory. Okay, and if your trademark is registered, you will have to prove just only this part. If you have taken the trademark registration, which is easy to see, even judge can see. Okay, that is why I repeatedly say that even though if you read somewhere that trademark registration is not mandatory in India, even then you apply for the trademark registration in India. Okay, for your startup or identity of the brand. Now, final slide of trademark. If you see Maggie packet, if you see some pen is around you, something is around you, some name is there, trademark name is there. You will see on some just right, just next to that name, this TM will be written. For Maggie, this R is written. For some other product, this R is written. What are these two signs? So name is there, name of the product is there. Right here somewhere it is written TM or R. What is the difference between this TM or R? See, if the trademark is pending for that particular thing or it is unregistered, they can only use TM. They cannot use R. But if R is written, that simply means that that trademark is registered in Indian Patent Office. Okay, that thing is the basic difference between any product. Suppose some product is registered, some trademark is registered, then it is the choice of the owner of the trademark whether he wants to use this TM or R. But if it is not registered, he can use only this TM, not R. So that is the basic difference between this TM and R sign that you will see on right next to the many names. Okay, so that is the final slide on trademark. So we have covered first intellectual property patent, then design, then copyright, then trademark. 4 intellectual properties we have covered. Last 2 intellectual properties I am going to cover one slide each and then we will wind up the session. So second last intellectual property that I am going to cover is SICLD, Semiconductor Integrated Circuit Layout Design. So if there is a laptop, in the laptop there is motherboard, there are circuitry elements, there is op-amp, there is capacitor, there is amplifier. The layout design of that circuitry thing in the motherboard of mobile phone or laptop, that design is not given the patent right. If you are in electronics and you are interested in some kind of basic design circuit or something, apply for those particular design I am talking. Okay, for layout design, you apply under SICLD, Semiconductor Integrated Circuit Layout Design. Do not apply for patent right. I am talking just about the layout design. Okay, if you have some other technical advancements, some other device kind of thing where you mention there, then you are most welcome to patent section. Otherwise, you come to SICLD. So this is one of those intellectual properties, semiconductor integrated circuit layout design. And the last intellectual property today is that we are going to cover today is geographical indication. You might have heard the news somewhere that Tirupati Laddu has geographical indication, or Hyderabad Halim has geographical indication tag with it, or Kanchipuram silk has geographical indication, Darjeeling tea has geographical indication, Kolhapur jaggery has geographical indication. What is common among all the names that I have taken? Darjeeling tea and whatever name I Hyderabad Halim, what is common? Madhubani painting is there which has geographical indication. The common thing in all these names is that they are associated with one location, Mysore Saturn, that has geographical indication tag. So some things, some products are there which are given the geographical indication tag by the government of India. What are the criteria for that particular geographical indication tag given to that particular product is this. Any product that has a specific geographical origin. For example, Hyderabad Halim has a specific geographical origin. Darjeeling tea has specific geographical origin. So if a product has some specific geographical origin and it has the quality or reputation because of that origin itself. For example, Darjeeling tea has taste because of that origin, the climate and the soil and everything. So that quality is because of that geographical origin. So not only the product is associated with that geographical area, but also the quality is because of that origin. and if not quality, then at least reputation should be because of that particular origin. Hyderabad Halim has the reputation of getting attached to Hyderabad. So origin is Hyderabad, reputation is related to Hyderabad. Darjeeling tea, origin is Hyderabad, quality and reputation is attached to Darjeeling. Okay, Dindigul locks, origin is Dindigul, reputation is getting attached to Dindigul. So these two qualities are there. So these two criteria are there. Origin is there and quality or reputation is there. So you can also see around something related to Bangalore or your native place, which is you feel that okay, this particular thing is made in my area only. So it is having some specific geographical origin and the quality or reputation is because of it being from your area. So then some association that can apply in our office for geographical indication tag for that particular product. Okay. There are many things you can see. This mango, Tippatladdu, Kasuti embroidery, Mysore sandal soap, Kanchipuram silk. So many things are there which have been awarded geographical indication tag. Recently, I think 1 year back also, Makhana was given geographical indication tag to some areas in Bihar. So that is, and now the question is, why? What is the benefit of having geographical indication tag, giving geographical indication tag to some particular thing? The benefit is manifold. Benefit is there. Suppose someone is making a flawed product. Suppose Darjeeling tea is given some particular geographical indication tag. Now, no one can take a rough tea or any rather a different tea and put a logo of Darjeeling tea and can sell it. Now, no one can do it because that particular geographical indication tag has been given to Darjeeling tea. So, the what to say, consumer gets confident that he is getting authenticated product, and when the consumer is confident, he orders more. Economy flourish. Not only that, there is cultural propagation of the things also, like Madhubani painting is given the given the geographical indication tag. Someone sitting in United States, they know that okay, they are actually getting the Madhubani painting, or they are actually getting the Kanchipuram silk sari. So now they order more. So exports also improve, and not only that, the money is also now moving to the actual artisan of producing. So there are many force benefits of giving geographical indication tag to some particular product. Now, concluding the session, I told you that there is not just one intellectual property. The very basic definition in the beginning I told you. What is intellectual property? Any property that you create using your intellect. And that can be anything, writing, painting, drawing, or invention, or computer program, or SICL layout design, or anything. Now, intellectual property right that is associated with the invention is LED display. So IP right that is associated with LED display is patent. Body of the laptop, which is adding aesthetics value to the product. So that body of the laptop is given the intellectual property as design. Apple sign is the identity of the brand. Intellectual property right associated with the Apple sign is trademark. User manual that is written, that is intellectual property right that is associated with the user manual is copyright. Integrated circuit layout design, that is intellectual property right that is associated with that is SICL design. So here you can see that there are many kinds of intellectual properties which are in the same product. So intellectual properties are all around you. You have to just look into them. And our offices, as I told you in the beginning, they are in Delhi, Mumbai, Kolkata, and Chennai. Delhi, Mumbai, Kolkata, and Chennai. 4 years back, I was transferred from Delhi to Chennai, and right now I am working in Chennai patent office. This is RGNIIPM. Actually, this place is specifically for training, and trademark additional office is there only for trademark. Here there are all the patent, design, trademark, everything is here. But trademark is specifically for trademark, there is one additional office in Ahmedabad. So if you have any doubt, you can reach out to us. You are most welcome to visit our office. And if you have further doubts, you can always write us on this email or this number. You are most welcome to contact us on this number. We shall be more than happy to assist you any way possible. Okay? So thank you very much. And I think Sir might have shared this Google link with you. If you fill that Google link, this kind of the certificate you will be given. Participant certificate is separate that you participated. It will be given by the government of India itself. There is barcode also. You can just scan the barcode. You can see it on the website also. So participant certificate will be given to all. Faculty separate certificate is there. Students certificate is separate. And appreciation letter is there in the name of the institute. And coordinator certificate is there. So that all will be given by the government of India. And if you have any doubt, you are most welcome to ask any question. Thank you so much.
Thank you, sir. It was a great honor to have you and sharing the knowledge and letting us know about the intellectual properties. Now, I request Dr. Asha ma'am, on behalf of management, to address the memento as a token of gratitude. Thank you, sir. I would also like to thank our principal, vice principal, and all the department HODs for organizing this event. And also thanks to all the professors and students who attended the event. Thank you, guys. There is a small announcement for all the students. 2 feedback forms are shared to your emails, and one is about the general understanding level, and the second one is test for 10 marks. Within 1 hour, I request everyone to fill the forms. And also tea is being served outside the seminar hall. I request everyone to savor it. Thank you, guys. Thank you for making this event.